Awesome. Hi, everybody. My name is JP Peters. I am with our Student Civic Engagement Office and our host of the Constitution Week 2022. So real quick, I wanted to quickly introduce Amy. So Amy Steigerwalt is a professor of political science at Georgia State University. Her research focuses on federal justice selection process, as well as the role of courts as institutions and the different influences on the court operations and decision-making. Her most recent book, Gendered Vulnerability, How the Women Work Harder to Stay in Office, co-authored with Jeff Lazarus, Dr. Steigerwalt, along with Drs. Carley and Ward, was awarded the 2013 Hugh Gossett Award for Best Article published that year in the Journal of Supreme Court History. Dr. Steigerwalt is a frequent panelist on GPB's daily show, Political Rewind with Bill Nugent, frequently offering expertise on recent Supreme Court rulings and relevant state laws. She has recently been cited in outlets such as the Atlanta Journal-Constitution, Washington Post, New York Times, Bloomberg News, and The Independent. Dr. Steigerwalt, thank you.
Great, thank you so much. Hi, good morning, and thank all of you for joining me today. I'm going to talk about some controversial topics like abortion and guns, because why not? Because that's where we are today. And so in particular, what I'm going to focus on are decisions that were handed down in the 2022 term of the Supreme Court. Do we look at that? How does that relate to the Constitution and how it's interpreted and where we go from there? So Nicholas, if you could give me the next slide. And of course, one of the big questions that we have coming out of the Supreme Court is, are they in fact political actors or neutral arbiters? This is just a selection of the type of political cartoons that came out in recent years, which about how they're viewing it. That we can, for example, identify each of the justices based upon the party of the president that appointed them, with the idea that there is a strong correlation between whether or not you're appointed by a Republican president and are you going to have a more judicial ideology, or you have a more liberal ideology. And many times we talk a lot about, as it says, sort of today's scores. What was the vote? 5-4, 6-2, right? With 5-4 meaning that the court was split, likely split on sort of those clear ideological lines. And especially if the only time you pay attention to the court is when we get into April, May, June of every year, when all of the cases are the most controversial, the most difficult, the most politically salient get handed down, you might think every decision on the court is 5-4 and split along these ideological lines. Now, does anybody want to take a guess of how many decisions of the court are unanimous? Meaning 9-0. Everybody agreed on the answer. Any guesses? Yeah, way in the back. 0. Okay, there was 0. All right, Nicholas, can you flip to the next slide for me? This is actually the reality. Between 1953 and 2004, the average percentage of unanimous cases every term was well above 50%. In 2005, it was actually 67%. In, I think, 2018, it was 68%. The reality is, most of the time, the justices actually do agree. And if we look at cases where, for example, so just to give you an idea of what this is, this lineup here includes cases where only a single justice disagreed with the majority, right? Those 8-1. We see the number is incredibly high. Now, this doesn't at all match up to what we see and what's going on, especially the way that the court is presented, nor, to be perfectly blunt, the cases we're going to talk about today. But it leads to the question, which I think is really important as we understand what was happening in those cases, of how is this possible? How is it possible that the court is agreeing so often, but when they disagree, it's so wildly divergent and disparate, right? I mean, they really basically either agree completely or they're at each other's throats. Next slide. So in a book that I wrote with my colleagues, part of what we argue is that the best way to be able to understand this, and this will really sort of apply to what we're going to talk about today, is to think about it as the idea that there is always law operating, right? As well as the justice's personal policy preferences. I'm a political scientist. Judges are political actors. Period, end of story. They're put in place by a political process. They are a member of government. Members of government are political actors by definition. And judges are asked to interpret what statutes mean. Every time a judge interprets what does a statute mean, what does the Constitution mean, by definition, they're engaged in the policymaking process. It's actually their job. They're not doing something that is untoward. That's literally their job, right? Our interpretations of things affect all of this. And so again, I'm a political scientist, so we just sort of like throw that all away, right? We don't believe that like it's only about law. Of course they're political actors, and right, that helps us to understand what's going on. But there are some times where the law is so clear. The legal considerations in the case basically act as a vise. And oh, that was very loud, sorry. It acts as a vise and allows, right, basically closes down, and so those personal preferences don't get to operate. But all of the information in the case points to simply one quote unquote correct legal answer. And that's for unanimous cases, right? Literally nobody could disagree. There was only one answer that we could come to based upon everything. On the flip side, though, there's a lot of cases that look much more like this, where there are not clear legal guidelines. There's not clear statutes and constitutional provisions that we can look at. And the problem is that when you are faced with something where the answer is simply not clear, using all of the other things that you could, then what are you most likely to look to help you understand it? Your own personal preferences. Because everything else doesn't really provide you a guide. And ironically, the two things we're going to talk about today, part of the reason why they fit here is because we're lacking one of the most important things that we need. Next slide. And that is a clear constitutional provision, right? My adorable slide that I found, because I really like political cartoons, talks about reading, and he says, after a cursory review of the preamble to the Constitution, I've deduced the country was founded by oppressed immigrant onion farmers. Friend says, what? Well, it starts, we the people of the United States, in order to farm a more perfect onion. It's form a more perfect union. Oh. Take your time when you read. Here becomes what's difficult. The Constitution is an incredibly short and pithy document. In total, if we include all of the amendments, all the original text, and all the signatures and annotations, it's a whopping 7,591 words. You all possibly wrote that in your last email. It's short. And particularly when we turn to the amendments, it's incredibly vague and ambiguous. It's not clear what any of these words mean. And even the ones that are clear, well, they don't really mean what they say. First Amendment, Congress shall make no law. Can you make a law that restricts speech? Yeah, in certain ways. Can you make a law that restricts the right free exercise of religion? Yeah, in certain ways. right? So we don't even mean where it says something that looks really explicit. We don't really mean that. Now, what do we do with provisions where it's not even clear what they mean, or maybe we would like it to be there, but it's not really written there, so we've got to try to find it. And that brings us to the right to privacy and substantive due process. So the punchline to all of this, which I've got sort of listed over here, is that there's a whole lot of words that we talk about in relationship to the Constitution that don't appear anywhere in the Constitution. The word woman is never in the Constitution, or female. Male does show up. It's in the 14th Amendment, because all men were given the right to vote. In the 19th Amendment, when it extends it, right, the right of suffrage to everyone, it still says, it doesn't actually say females, it says sex. But a lot of other important words aren't in there either that we talk about a lot, right? Privacy, abortion, as we'll talk about in a second, family, children, marriage, heterosexual, homosexual, pregnancy, travel, reproduction, and a whole host of other things. And part of the reason that that's important is because that's what the court gives a lot of attention to. But on the other hand, there's a lot of ambiguity. So the 14th Amendment, and where the right to privacy comes from, is it says, nor shall any state deprive any person of life or property without due process of law. The basic interpretation of that is that it's referring to criminal charges and saying that before you can be put to death, put in jail, or fined, you have to get due process. So that's the Fourth Amendment, rights against right, search and seizure, Fifth Amendment, Sixth Amendment, right, all of those, actually the Eighth Amendment, Seventh Amendment, juries, excessive punishments. That's where that comes in. Is liberty really simply about, am I in jail? Or does liberty mean something else? Is there something more when we say that we have liberty, right? That we have an existence, that we are people, and what comes into that it goes. So the first variant of this, though, occurs in 1905 in a case called Lochner v. New York. New York had passed a series of laws that stipulated working conditions in bakeries. It used to be that if you worked as a baker, your likelihood of dying a really horrible death was very, very high. There were no regulations about ovens and things like that. There was also no ventilation required. And imagine that you're constantly breathing in large stacks of flour and other baking ingredients. It basically causes to something that looks like sort of emphysema from smoking, if not worse. So New York passes a set of laws to say, no, we're going to start to regulate this. We're going to regulate the number of hours. We're also going to suggest that there needs to be, for example, windows, right, to make sure that there's a place for it to go so it's not all trapped. And the court says, well, but wait, liberty. Liberty means of all of us to enter into employment contracts. And so if you, wise person looking for a job, want to agree to work at a place where your likelihood of losing a hand, falling off a well, doing whatever is really high, you should have that liberty. And the employer, of course, should have the liberty to make sure that you can sign such a contract. Because you've got free will, you can say, put in place liberty of substantive due process. It lasted approximately, because in a case called West Coast Hotel v. Parrish in 1937, as part of actually, right, that switch in time that saved 9 with Roosevelt and talk about, where there was sort of a hint that possibly he was going to pack the court to get them to change their positions. They said, oh, doesn't. We made that was a terrible decision. What were we thinking? So, as you can probably guess, we see a lot of parallels in what, of course, comes with the next version of trying to say that there's something called substantive due process, of a group saying, no, we need to understand. Now, of course, now it goes the other way, right? The original version was really about employers' rights, right? It wasn't sort of about an individual right. It wasn't about sort of expanding, right, sort of individual freedoms, right? In many ways, really what it worked to do was curtail it, right? Because it took away possible protections, right? But so there is a shift in that sense. But what we see coming, right, again, in the starting really actually in the 1920s, around the same time, and continuing on, is a revisiting of that one, but for a different version of it. So the second version that we get, which many of us know is the right to privacy, right, with Roe, that then also, right, helped extend, for example, same-sex marriage, et cetera. One of the first cases where that actually occurred was a case in 1923 called Myers v. Nebraska. And it was about the question of how much control did parents get to have over their children's education? And the court said, oh yeah, that's actually really important. Right? Parents, like, there is in fact a way in which they need to be able to make those decisions to make sure that they're protecting their children. And where they put it, where they kind of came up with the idea, was in this liberty portion. Similarly, the court later on would say that you have a right to travel. Now note, the Constitution doesn't say anything. The word travel doesn't appear anywhere there. But in a later case, the court said no, right? We cannot prevent people from moving from one city to another or from one state to another. Because again, how can we have liberty if we're not able to, well, live where we want and be able to move places and go to other realms, right, of the state? We see it pop up in other cases, right, that are sort of, again, in these sort of things. We also see it, right, even before, right, it's sort of a long, but before we even get to, or around the same time, in cases such as Loving v. Virginia, 1967, where the court struck down anti-miscegenation laws. Now, that case technically also hit the other part of the 14th Amendment, equal protection, saying, got similarly situated people, i.e., two people want to get married, of course, at that time, a man and a woman, and the law in question is treating differently two people who want to get married if, on the one hand, they're either both white or both black, or if one of the members of the couple happens to be white and one happens to be black. And so that's a violation of equal protection. But the court also decided the case on liberty grounds. And there is a right to marriage. Now, the word marriage doesn't appear anywhere in the Constitution, but the court said there's a right to marriage. You get to choose your life partner. That is fundamental to the ordered liberty that we think of, right? Our notions of ordered liberty. The court really likes that term, ordered liberty, right? From the nation's founding, right? They even went back to sort of biblical, right? It started with Adam and Eve, right? The whole point was you had to have this coupling. That's the only way that we get future generations. So that must be part of it. And it must be that you get to have a choice of who it is that you're going to marry. So that's where that idea of a right to marriage and also this idea kind of marital privacy starts to show up. And that's super important because that then gets us to the foundational cases that start off the right to privacy and abortion. So in that same time, right, in Loving v. Virginia's happened as the court decides Griswold v. Connecticut. That was a Massachusetts law that said you were not allowed to be counseled or be given contraceptions, even if you were married. They challenged the case, and part of what the court said is that their Constitution, not written there, right? It's unenumerated, but in its penumbras, kind of the auras that surround it, right? Imagine that you've got words and then there's like floaty things around it. That's kind of the best terminology I can come up with this. You got to get all touchy-feely and new agey on this one, but like that's what the court was talking about, right? So you had a bunch of, older white men who were like, no, no, no. Imagine that there's other words written there that you can't see, but promise us they're there. And they give us a right to marital privacy. Now, where is this right to marital privacy? Because remember, the word marriage isn't there. The word privacy isn't there. But they take it out of a whole variety of portions of the Constitution. Number one, the First Amendment, talking about the idea that a lot of the things about free speech, all of that is really about personal freedom. And so it suggests this kind of notion of personal liberty. Third Amendment says you cannot be forced to quarter soldiers in your house, right? Because your home is your castle. That's your place. Other people don't get to come in. So it suggests that there is some privacy that you get within it. Fourth Amendment, search and seizure. Again, the state is not allowed to enter your house without either your permission or a warrant that shows a really, really darn good reason to override the fact that you're not giving permission. And so if you don't give consent, you've got to have a darn good reason. Why? Because again, your private space is yours. It's private. You don't have to share it out with the public. Also, the home is where, right, a lot of the private marital things take place, generally speaking. Ninth Amendment. The Ninth Amendment is a spectacularly broad amendment that says all of the rights that go to individuals that haven't been specified above in the first 8 amendments are still retained by the people. This is the first and last time that the Supreme Court has ever referred to the Ninth Amendment. It basically does not exist. So on the one hand, things get written into the Constitution. On the other hand, the Ninth Amendment, you should not read it. It's not actually there. You only think it's there. And it's there for, scholars like me to sometimes mention. And then the 14th Amendment, these notions of liberty. Right? So the court says all of these together create this right to marital privacy. And this right to marital privacy means the state should not be interfering with, what the married people want to do in their home, including the choice to, quote unquote, bear or begat a child. Eisenstadt v. Baird, 1972, the court says, yep, it's a right to marital privacy, but marriage is made up of 2 individual people, and so therefore this right to privacy extends to all individuals, married or not. Everybody with me on that one? Right? Sort of fascinating line that they do. What they technically do here, and this is sort of also what's important, technically it was an equal protection case. Because the court said we're treating people differently, right, based upon something that really is not related to the point at hand. But the most famous line, which comes out and which gets repeated right into the future, and you've probably heard it and didn't realize where it came from, is if the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision of whether to bear or begat a child. Which then leads in the next year to, of course, the court deciding Roe v. Wade, in which they much more explicitly, right, are looking at this question of bearing or whether or not this right to privacy extends to the decision to, in fact, terminate a pregnancy, right? All the prior cases were about contraception. So theoretically, we're sort of before pregnancy, trying to prevent it. Now we're at pregnancy and the question of whether or not you can come. The other thing that this case did is it recognized that there were, right? The woman had this liberty interest that went to her, but it also recognized that there were two compelling state interests, because that's how, right, the reality is, and whenever I teach civil liberties, I tell my students, if you learn nothing else, I want you to learn this: no rights are absolute. No rights are absolute. Because if the state has a compelling interest to limit that right, then they get to. It's always, almost always a balancing. And here the balancing was, number one, protecting the health and life of the mother. Because yes, pregnancy can be incredibly life-threatening, if not fatal. And also protecting potential life, which is why we get the trimester system. And I know that you guys are, most of you are in a class where you're studying abortion for most of the semester. You've had that. But so very quickly, for those of you who aren't, the trimester system is from sort of start of pregnancy until the 12th week of gestation. The idea that it should be a decision between the woman and her doctor, because it is framed as a medical decision, a health decision, and one that is properly made there. During the second trimester, so now we're at weeks 13 through approximately 23, 24, the argument is that now this real concern of protecting the health of the mother kicks in because, in part, 12 weeks and earlier, abortion is safer than childbirth. Starting at around week 13, the argument that the court gives is that if we look at it medically, we start to see that there are ways in which, especially because, right, this is 1970s, that childbirth becomes more, and so they want to make sure that they're protecting the health of the mother, and so protections that are about that. So saying, for example, it must be administered to by a doctor, right? It can't just happen wherever would be allowed. And then finally, right, they create what they know as the viability line. The idea being that in that third trimester, when you hit about approximately, 24 weeks, that you now, that is where the fetus has now become a child and could exist outside of the womb. And at that point, childbirth is safer for the woman than abortion. And so that is why the state may ban it, assuming that they have an exception for the health and life of the mother, right? That runs throughout it, right? The health and life of the mother and being concerned about that. So in between 1973 to 2019, almost immediately, this is actually a really famous sort of set of political cartoons that came out to on the anti-abortion side in 1973, not long after Roe was decided. It was a whole series that was called Who Killed Junior, to try to say this was a terrible decision, right? So politically, we have pushback, much like we saw with many of the other decisions of the time, to be blunt. Right, but we also see sort of as it keeps going, this one is talking about sort of KCV Planned Parenthood and recognizing that which is what is true, right? We saw a lot of debates happening in the political stage, in the state legislatures in particular, passing laws to try to figure out what were the boundaries, right? When they start to say in that second trimester that there can be limitations put on it, what does it look like? And so, right, there were these sort of different hoops that were put in place. You could now have a waiting period, informed consent, spousal notification, parental consent, assuming now that you have a judicial bypass, and things like that. And we also start to see, right, which is what this one over here says, is it's not just about the state legislatures acting, but also the change on the court, right? So that scales looks like it's starting to tip because, wait a second, Roberts joins the court in 2005. And now we're starting to see a shift in the court majority on that political realm. Nicholas, next. 2018 and 2019, we actually see a massive shift in how the states approach the question. For one of the first times ever, states say, you know what, we're not going to pass these laws that say, oh, you can't do it after this amount of time, 15 weeks, 16 weeks, moving the viability line. We're not going to focus on late-term abortions, things like that. We're just going to pass a law that, well, bans it. Right? So Alabama, Georgia, Louisiana, Mississippi, Iowa, Indiana, whole slew of them. By the end of this time, almost 17 states have passed some law that bans abortion, right? With many of them banning abortion somewhere in the 6 to 8 week period. Now, when they passed these laws, they knew they were unconstitutional, right? Supreme Court doctrine was very clear. They could not ban abortion prior to viability, and that's what each of these laws was doing. But they were written for one purpose and one purpose only: to get the court to reconsider Roe. Also, what happened in sort of 2019, which caused, right, all of these state legislatures to think, hey, this isn't a terrible idea and maybe now is the time? A shift of the court majority. Right? We see Merrick Garland is blocked from even being considered as a nominee to the court. They hold it until President Trump takes office, at which point we then see, of course, Gorsuch and Kavanaugh get to it, and that shifts the balance of power on the court. And so we now go, right, the 5-4 shifts, particularly on abortion. Which leads us to 2022 and the decision in Dobbs v. Jackson, Women's Health. Somewhat ironically, this was one of the law that ends up being actually addressed by the court because it got through the system faster, is basically what happened, was less dramatic than many of the other ones. Right? This one was still a very clear, direct challenge to Roe and to Casey, because it said that it was going to ban all abortions as of 15 weeks, which was prior to viability. But it was not, for example, one of the heartbeat bills. It was not one of the ones that banned it completely, right? And so that was sort of interesting. And there were a lot of ways that the court could have gone on it. The court decided to not only uphold the law, but to also take the affirmative steps to strike down Roe and Casey, and to say that they were erroneous precedents, that it was a failure of the past justices, that they created out of nothing a right to privacy that simply doesn't exist in the Constitution. And part of what they focused on a lot was that the word abortion is nowhere in the Constitution. It's never there. They spend a lot of time discussing the fact that the word abortion is not in the Constitution. The word privacy is not in the Constitution. This is an unenumerated right, which is really sort of the bastion of judicial activism. They also spend, which we're going to come back to a lot of time talking about the idea of whether or not, and they come down on the not side, abortion is, quote, deeply rooted in the nation's history and tradition. When the 14th Amendment was passed, what were the laws at the time? What did people think about this? Where did that go? How did that apply? It was very much an original interpretation of the Constitution, which says the question to ask is, what did those who wrote the provision of the Constitution intend? Not what is the reality today, but what was the reality when it was passed? And they said, well, when it was passed, according to the court, because there were, in fact, dueling sort of legislative histories, but according to the court, that abortion was not something that was really allowed. And so therefore, we can't understand that as part of our sort of notions of ordered liberty. They also spent a lot of time in the court in the case, talking about the protection of fetal life, right? So while that did come out of Roe, what was not in their decision, which was very much a big shift from sort of all the previous jurisprudence, was that other compelling interest, right, that the court has had continually up till now given a lot of attention to, the health and life of the mother. In fact, the word woman appears very infrequently in the court's decision. It's primarily in footnotes. I may or may not have gone through it. It's primarily in footnotes where they are talking about like various laws that had been passed through time historically that were sort of referencing that. But the actual discussion really doesn't talk, right? Talks about a right to abortion, but it doesn't frame it really in the concept of who is it that possesses that right and is perhaps the one who is utilizing it or making the choice whether or not they want to utilize it. The other thing that comes out of this case are dueling concurrences that are terrifically important. So Justice Alito writes the majority opinion and says, don't worry, we're just talking about abortion. Justice Kavanaugh, who voted with the majority, writes a concurrence to basically stress in even more pages, don't worry, this is just about abortion. It's not anything else. Sure, there's this other right to like marital privacy and stuff, but don't worry about it. The case is just about abortion. Justice Thomas, on the other hand, no, I mean, they're right. This case was just about abortion, but of course we should reconsider all this other crap. There's no broader right to marital privacy. Yes. And he explicitly mentions Griswold v. Connecticut, right to marital privacy, contraception. Lawrence v. Texas, which extended the right to privacy and the idea that you are engaging in sort of consensual acts in your home to same-sex acts. These were striking down sodomy laws, and to Obergefell v. Hodges, which again used that same line of reasoning, also used the line of reasoning in Loving v. Virginia to extend it to same-sex marriage. Now, somewhat notably, the one case he left out in his discussion was actually Loving v. Virginia, which is about anti-miscegenation laws. So that one left out, but he explicitly talks about these other ones. And he also doesn't talk about a bunch of other ones that go into this, right? So Moore v. East Cleveland, about who you can live with. Skinner v. Oklahoma, forced sterilization, right? The case is about being able to have control over who you're teaching because all of those go in together. So where we are left is the question of how far does this go? And what are we doing with this, especially if the question we're now asking is, how does this relate to the views at the time of the founding? Which actually leads nicely into the Second Amendment case as well, because we have sort of a similar thing going on. So with our Second Amendment case, we do have a constitutional amendment. We can point to it, we can read it. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So here, it's not a question of an unenumerated right, but it is a question of, what does that mean? And in particular, there's two clauses. So how do we interpret them? Is this first clause talking about a militia actually the point of the amendment, that it's all about having a well-regulated militia? Because remember, we're talking about, 1789, where they were worried about, right, there wasn't an army. And so saying like, okay, therefore we need people to like have guns in their house because we need to be able to call them up in case like the British attack again, or the French or whoever. Or is it simply kind of an introductory clause with no meaning? And really the only part that matters is about the right of the people to keep and bear arms. Until 2008, so through 2007, the Supreme Court said, it's about a militia. I mean, that part of the clause came first. It's about people being able to, right, yes, that you have guns, but really it's about having those guns so we can call you up when need be. Right? We didn't have National Guards. We didn't have a standing army. We might need to be able to call on you. And so what that means is states can put regulations on individual gun ownership. Right? Yes, you can have them, but they can also greatly restrict it. 2008, first time ever. Court says, actually, no. It's really about an individual right. We've all been reading it incorrectly this entire time. It's about this individual right to bear arms. And so that means, yeah, you get to be able to own a gun at home if you want to. But the court still put quite a number of restrictions on it. In fact, perhaps what the decision is most notable about, remember I said no rights are absolute, is the decision spends more time discussing here's all the limitations that are still okay, even with this new interpretation, than it does talking about how far the reach of it goes. So, and it explicitly talks about, for example, banning weapons in sensitive places like schools, churches, public parks. It talks about being able to say that, right, felons are not allowed to own them. All of that is coming in. And in part, it creates a test that says, does the conduct fall under the Second Amendment and our sort of historical understanding of it, but then also whether the justification for the regulation outweighs the burden created by the regulation. That balancing test, right? That sometimes there are these compelling state interests like public safety that might override the individual right. And we see those with all other things. 2022, we have now a case that is about carrying guns outside the home. This is about, it's a New York law with licensing, and is asking whether or not who's to get. And in part, this law says that you have to show, quote, a special need for self-protection outside the home that is distinguishable from other people. Right? You had to have some special, right, vision rather than just thinking the world is a scary place. And you had to show cause, which also meant that they could say, nope, you did not adequately show cause. The court strikes it down. They say that the individual gun, right, that before was also sort of limited to ownership in the home, extends to outside the home as well. That we have an individual right to self-protection, an individual right to gun ownership, and, which is perhaps the most important part, that there's not actually as much ability of the state to regulate that right. And in part what they do, and this, again, if you sort of look at this test and we compare it to also the discussion that took place, right, in Dobbs, these two are really a mirror because, again, the court says the question is now not balancing interests, right, limitations. It's simply, quote, is the regulation consistent with the nation's historical tradition of firearm regulation? What did they mean when they wrote the Second Amendment, and what types of things were allowed in 1789? So what comes next? And this is where we're going to start to open it up for question and answer, and hopefully I've given you a lot of things to think about. Both of these decisions are notable because they take us back to the argument that it's not simply about what does the Constitution say, not how is the law evolved, not what are, right, these competing interests that might exist, but rather that the base question we need to ask is, what did the people who wrote the law mean? Period, end of story. If we look at the time, what was their expectation? And if the state statute doesn't match up with that, then it's simply not okay. Right? It's taking us to a question. And so what that leads us to are a bunch of really, really important questions as we go forward. Number one, what is the role then of stare decisis and precedent? Right? In both of these cases, the court in part said, well, not very much. Right? It doesn't matter as much that we had all of this because fundamentally the question is, what did they mean when they wrote it? That is the correct way to interpret the Constitution. And so therefore, we are going to prioritize that over, right, all of the cases that we've had leading up and the possible reliance interests that people have had. And it leads to a super important question of how do we read the Constitution? What do we do with it? It's the year 2022. It's about to be 2023. Many of these provisions were written in a time where, I mean, let's be blunt, in 1789, do you think they could imagine that I could talk to all of you on my phone or on my watch? They didn't have watches, they had sundials. They didn't know about modern technology. Let's also be blunt, most of you in this room, under when most of the provisions of the Constitution were written, didn't actually have any political rights. Right? That's all changed. And so in part, we are now confronted with this argument of how do we address this, right? How do we understand the Constitution? What should we do with it? Where is this debate go? How are these provisions meant to be understood? And also what's right? Because the other side of it, if you go and look at both of these decisions, is both sides present really detailed histories to back up their sides. And on some level, the court said, well, so we're going to pick which one we think is more persuasive. But that in and of itself, the reality is, it's not clear, actually, what was meant. It was not entirely clear, right? That's why you can have even not just dueling constitutional interpretations, but dueling histories. Right? And is it in fact the job, right, again, of the court to say, this is the correct history, as opposed to this history of where we have it? How do we understand it? And even more so, what do we do with the vast majority of unenumerated rights that exist in the Constitution? Because it's not simply the right to privacy, right to association. That's unenumerated. Right to travel, unenumerated. Right to marriage, unenumerated. Right to exercise control over your child's upbringing and education, unenumerated. So what do we do with those also? Right? How many of them are we now sort of bringing in, and what is that going to mean as we go forward in interpreting all of these? And so we are really at a watershed movement that brings us back to kind of this core question of what is the right way even to read the words that are on the page and to understand the broader implication of these words on this page, especially if we can't agree because they're not actually necessarily all that clear in the way that they're written. So questions, comments, thoughts. I think you are invited, if you'd like to ask a question, to speak into there, because they are live streaming this over to the perimeter campus. If you've got questions, you could walk up and use one of the things. That would be awesome. And I think JP was also going to see if there were any. Please ask questions. Hi.
What do you think the role of the judicial system ought to be in our particular system? Do you think that it's their job to interpret laws into the modern age, or should their job strictly be to interpret them as they think that they are or were, and people should change laws as times change rather than them changing interpretations as time change?
So I'm really annoying because I'm an academic, so I'm not going to give you my personal opinion on this, but I can give you sort of the differing views. So Justice Clarence Thomas is probably the most adamant person to argue, look, we have a constitution, it was written. If you don't like what it says, change it. That's why there's an amendment process. Right? That's the proper answer. The proper answer is not for judges to say, this is really what it means or where it should go. Amend it. The flip side, which we see from, for example, Justice Kagan, Sotomayor, now Ketanji Jackson Brown, for the argument that the Constitution was a guiding document. It was given to us in order to work throughout time. It wasn't meant to be a document for 1789. Yes, there's an amendment process, but the amendment process still was not meant to have to, rewrite everything, because it's a really difficult one, right? We've only had 27 amendments, only 17 of those have really come since the Bill of Rights, right? So only 17 times have we been able to truly amend it. And what we need to do is interpret it, right, not as it shifts with the winds of time, but to recognize how the world has changed so that we don't have to constantly amend it. And to recognize that when they wrote some of these amendments, they really could not have fathomed what was going on at the time. Right? The Fourth Amendment is probably actually the best example of that, where everybody on the court agrees we can't understand it in the way that they wrote it. We had to shift it for modern times. Why? Because the original Fourth Amendment is talking about a search of your home and things. It's all tangible. So early on, when they created phones and they created wiretaps, in a case called Olmsted v. New York, the court said, well, they captured sounds over a wiretap? That's not what they were talking about in the Fourth Amendment, right? The Fourth Amendment was about, and this is one of my favorite tests the court ever came up with, physical intrusion into places. They didn't walk in anywhere. That was the whole point. They were able to listen to it, and they were really far away. So they didn't go into the house. They didn't go into the office. They didn't violate that sort of sanctity. So that's not what the Fourth Amendment means. Now, the court not long after that said, yeah, that doesn't make any sense. Because now we've basically said that as long as you create super awesome technology that can violate, right, privacy, I don't know, things that can see through walls, which, well, we kind of have, right? Thermal imaging detectors, right? Big microphones that can capture stuff, then you really have no privacy anywhere. And that can't be what it means. Instead, it's about the idea that when you're trying to keep things private, you're keeping them private. And when you want them to be in public, they're in public. So, now it sounds like I'm talking about a right to privacy, doesn't it? Right, which is partly where that came from. But that is a really good example of where the court itself, and even the current justices on the court, say, no, we can't understand the Fourth Amendment in the way that it was what they meant at the time it was written, because they could never conceive of the stuff we have today. So it had to shift to be able to recognize that, or it basically became meaningless. And so this is really the struggle, right? Which part, because even with the originalists, guess what? Justice Thomas also agrees with that interpretation that I just said of the Fourth Amendment, right? He would never say it can only be restricted to what they thought in 1789. And so this is where the struggle really comes in many ways, it's almost as though we're asking which part of the Constitution do we say we want to interpret literally, textually, originalistly, and which parts of it do we say, well, it makes it so unfathomably unworkable that we can't rule that way and say to everybody else, go amend it, because that just doesn't work and would be sort of awful, so we'll have to rule instead. And this is really the conundrum. So it sort of leaves us with, I mean, the justices get to make that decision, but that really does come up and bumps up, and that's part of the problem. I mean, you're really highlighting the essential tension of all of this, which is it was a document written in 1789, and parts of it still work really pretty well. Other parts of it don't make any sense at all anymore. And so what do we do? Is the correct answer to have the justices sort of have it match up and decide that? Or is the correct answer to say, well, this is what it says. If you want to fix it, amend it. Bring it up, have a constitutional convention, have it go through the states, have to get all the states to ratify it, right? What is it that we want to do and how do we want to approach that? Sorry, I'm not going to give you the answer you want.
Do you have an opinion about which one's more persuasive?
Not going to answer.
We do have some questions online.
Okay, why don't you go ahead and read one of those as the next people walk up.
So we have a question from John Paul Hollis. Do you know of any cases in the court system at this moment that could challenge Obergefell's decision?
As far as I know, there is not anything currently that is in the system that would challenge Obergefell. Cases will not necessarily start directly with, for example, challenging Obergefell. I think where they're instead going is they're going to stick on the abortion realm, and probably what we're going to see much more quickly are cases that start to challenge Griswold and Eisenstadt v. Baird, right, with contraception and about decisions made sort of in the private home, because then that leads you more easily actually to challenging things like Obergefell if you wanted to.
So I had a question about when you were talking about the state bans on abortion that occurred like 2018, 2019.
Mhm.
I don't understand how if we had Roe v. Wade and that was a federal decision, how the states were able to do that in the first place. And that's just like, I didn't, know what was going on. But is it just that nobody stopped them from the federal level, or what even have they do?
So that's actually a great question. And the reason it's actually an even better question is because that's actually the question in front of the Fulton County Court now about the Georgia HB 481, the so-called heartbeat bill. Technically, all elected members of the state assembly, as well as the US Constitution, take an oath to uphold the Constitution. Right, to uphold the state constitution, uphold the federal constitution. And within that generally means don't pass laws which we know conflict with the Constitution. Part of what happened in 2018, 2019 is a bunch of state legislators, in part because they felt emboldened by the changes in composition on the court, said, we're going to pass laws that we know are unconstitutional, and we're doing so explicitly because we want them to be struck down by the lower courts, and we know they will be, but we want the Supreme Court to accept it and reconsider its precedent. So they did so symbolically, right? Because that's sort of the flip side of it. To be perfectly blunt, no one who voted for the law, for example, in Georgia or Alabama or whatever, they didn't honestly think it was ever going to go into effect. They didn't really, which also explains why if you go read the law, it's sort of nonsensical in a couple places, because it wasn't written to actually go into effect. It was written as a symbolic statement. So the reason that this becomes important, as I said, is that vision of, so the Georgia Constitution is what stipulates, right, about taking that oath. The Georgia Constitution also says, though, that the state legislature may not enact a law which conflicts with either the state constitution or the US Constitution. When, of course, they enacted the law in 2019, it blatantly conflicted with the US Constitution and therefore as well. So that is actually one of the main arguments that is being actually debated right down the street. You guys can actually go listen to it if you want to. Just Judge McBurney has all the big cases, actually. He also has all the fake elector cases and everything dealing with Trump with Fitting Wallace, but he's literally like right over there. And one of the primary arguments is this law, right, the 2018 HB 481, invalid because when they enacted it, it was unconstitutional, and so therefore they didn't have the power to pass it in the first place, which automatically voids it. And so that is being debated right now, and I'm actually really serious, like, pay attention to that, because that's going to be a huge deal to see. It is also going to be, because here's sort of the other flip side, is the second question that is happening within that case is, does it conflict not just with the US Constitution, but with the state constitution? There is currently, under current Georgia Supreme Court doctrine, a right to privacy, which is under the state constitution. And it's actually much broader than the one that had ever been sort of talked about by the US Supreme Court. And so the secondary challenge is, does this conflict with the right to privacy that the Georgia Supreme Court has established and said, which is actually a really pretty broad one. And in particular, there's a number of cases where the court, for example, has said that you cannot force people to have to undergo or be blocked from undergoing certain medical procedures of choice.
I have another question online.
Yes.
So this is from a student. Does Dobbs mean that the court will refuse to take any more abortion cases since they've basically thrown the ball to the states?
That is the base argument that they're making, is that abortion is not a constitutional question anymore as to whether or not a state law or a federal law conflicts with the Constitution. And so in that sense, yes, we are not likely to really see cases there. It could happen, because here's, of course, the flip side of this is, should they have taken cases, right, even this case, when we knew that it very clearly conflicted with precedent? There are going to be those who are going to perhaps try in different realms, because they might want to, again, flip the other side. It is going to be much harder, though, and so we're probably less likely to see that. Related, though, because it's not abortion, but it's in the same realm, but of course the court said they didn't rule on it, is everything else that sort of goes along with that, which would mean cases about so it's unclear where medication abortion fits in with this, because that is somewhat of a different procedure and there's sort of different ways. And also some of the medications are used for other things. We're definitely going to probably see cases about contraception. So not just birth control, but also things like IUDs, morning after pill, all of that. We perhaps will see cases that also start to pop up, though, that are kind of the flip side of it, is what does it mean once these laws are kind of put into place, and other arguments that are brought to try to maybe, right, sort of say that this should attach to a different area, right? Because to say that there's maybe some other constitutional provisions. So it's not quite as easy as saying the court will never deal with it again. However, and this is, of course, the really big thing, the Supreme Court decides what cases it hears. Remember, I showed you with the gun cases. That was kind of a great one. The court literally, for 73 years, did not hear a case about guns. They were like, nope, we just don't want to hear it. The court could do similar, right? There could be cases that try to bubble up and, in fact, are appealed, and the court can say, we simply don't want to hear them. So it's kind of unclear what's going to happen there. Oh, yes, sorry.
I was gonna say, I don't think it's like crazy to see like precedent be overturned. Like, it does happen, but it's more rare to see it in a scenario where it takes away rights rather than expanding it. And so I was curious what you think, because I think this is a big fear in a lot of people right now, how that is gonna play out in other areas where we've gotten used to having certain rights and how that could be a dangerous situation or they could be taken away.
So you are exactly right. This is the first time ever that in overturning a precedent, the court has taken away a right. So even in the court spends a lot of time, particularly in the Dobbs decision, discussing previous precedents that were overturned. In all of those, it was the overturning of the precedent that expanded rights. So they talk about, for example, overturning of Plessy v. Ferguson, right? Separate but equal. They talk about overturning of Dred Scott v. Sanford. That was the ability of freemen to be able to move between areas, right? And in each of those instances, the precedent was what was sort of more restrictive and didn't allow, and it led to this. So this is actually the first time that there's ever been a retraction or a taking away of an individual right under the Constitution. And part of what I think that for those that hold that fear that it is going to continue and that there might be other rights that have been granted, it is certainly not unfounded. And I think is why we saw, number one, some of the justices spending a whole lot of time saying, don't worry, that's not what we're doing. We're only talking about abortion. And then, of course, Justice Thomas said, oh, no, nope, bring them all. Let's go. Because yes, all of those rights suck too. They shouldn't exist. They're unenumerated. The court never should have done that. Bring them to me. I'll take care of it. So yes. I mean, it is very likely that those are all going to be challenged as well. Now, what order it's going to happen, how it's going to happen, I don't know, but certainly at least one of the justices made clear that that is precisely what he would like to now have happen. And again, the easiest one, sort of easiest in sort of a legal sense, and of course of things that can be challenged and of where there actually are state laws that would make it easy to potentially challenge it, is Griswold v. Connecticut and Eisenstadt v. Baird with contraception. That's kind of the first one where I think it'll sort of like most easily go, but yes, it's highly possible.
There's also a follow-up kind of to that question. How would this affect other precedents? And then what would be a next step for Congress?
So two really good questions. So does it affect other precedents? So other precedents still exist until there is a new Supreme Court case, right, where the court, in a new Supreme Court decision that says, nope, right, we're getting rid of that precedent as well. And so what it means is that all these ones that I'm talking about right now, where I'm saying this could be the next logical step, especially because Justice Thomas said, right, this is where you all should concentrate your efforts on, right, those are still good law. So right now, there is in fact a right to marital privacy or a right to individual privacy that extends to, right, intimate decisions really about sex. That's kind of where it goes to. So this idea sort of at the point, so having sex, protection of sex, who you get to have sex with, who you get to marry, right? All of that currently is in fact still good law, good precedent. But what the court, and particularly, right, that one concurrence, but really what the court is sort of signaling more broadly is that they are much more willing to reconsider these precedents that have been in place for quite a while and to possibly overrule them. And that they do not necessarily, that they think that this group of justices thinks that it is, that there is no concern about having an argument which says, even if this has been in place for a long time, even if people are relying upon it, that the fact that it was wrong, as they started off, they said Roe was wrong when it was decided, and it is still wrong today. And so that's really all that matters. What we're doing is we're correcting an egregious mistake. And that's the only way that it really should be understood, right? What happened in the middle there was highly problematic. And so that's where this is coming. Now, what can Congress do? Oh, Congress can pass laws. just like the states can pass laws, right? What they have now said is, and this is sort of the flip side, is they said, look, this isn't a question for the judicial realm. This is a question for politics. This is a question for policy. This is a question to be debated and to go through the legislative process. So yes, Congress has the ability, if they want to pass a law which says, right, that abortion should be, right, abortion rights should be protected, that women should be, and to put in, now granted they have to deal with the interstate commerce clause stuff, so they aren't able to sort of simply like say it completely, but there are protections they can put in there, but they can pass laws about that. They can also, now if they wanted to, pass a law which says abortion is banned everywhere. The reality is we are much less likely to see action taking place on the federal level due to, right, sort of the division, especially, right, there's a split Senate, et cetera. So neither side is going to get, right, the support that they need, that supermajority 60, right, to be able to really pass stuff on the president on the federal level, right, unless we see a really big shift in the makeup of the House and the Senate. The president has some ability, and we have seen that, to issue executive orders. Now, executive orders have to have an authorizing statute that gives them those powers. And so that is where we have seen, for example, right, under Medicaid, some of that, that's where we've seen the executive orders about pharmacies and things like that. And so there are some powers there, but they are, again, much more limited, and it's more difficult to do it on the national level. And I think we might be, do you want to do our one last question and then we can go?
It's just well, I don't know if it's simple or not, but since the issues are so like, the opinions are divided so well, would the ratification process be, like, would they be strong enough to go through the ratification process, or would it be more like leading to a state rights issue from a like political perspective?
Politically speaking, and I think this is probably the best answer, right? Since 1789, there has only been 17 successful amendments to the Constitution. There's been very few. It's incredibly difficult to do. The most recent one, of course, that was tried was the Equal Rights Amendment. It failed. It fell 2 states short of ratification, even after they extended the deadline for those purposes. And this is a topic which obviously has quite divided views and things like that. The other side of it is that, well, on the one hand, right, polls suggest that, in fact, support for the ability, right, to access abortion services is much larger than we might see from sort of the states and what the legislatures are doing. The other sort of side of it, though, is that people have to actually turn out and people complain a lot, but they don't actually get involved and vote, and they don't have a say. And so that's why we end up many times, right? So if you don't like your elected, so I'll end on that for the Constitution, right? If you don't like your elected representatives, vote. Take your friends to vote. Get everyone you know to vote, because this is how we can change it. If you want to change it, vote, organize, get involved, right? Politics is not something dirty. It's not campaigns. It's policy. It's decisions about what's taught in your classes. It's decisions about how much tuition are you going to pay. It's decisions about, can you access contraception? It's decisions about all of this. So if you care about it, vote. There's an election coming up kind of soon, actually. You can still register to vote. Vote. Take your friends to vote. Get involved, because part of the reason we end up, right, a lot of times with laws on both sides that people don't like is because people don't pay attention. They don't speak up. They don't get involved. And it's those who speak up that get their views put into place. So if you don't like what's going on, speak up, vote. For the love of God, vote. Especially the people in this room, right? Who's least likely to vote? People under 35. So